This Tuesday, 21 March 2019 hearing officer meeting is called to order. I am Los Angeles County staff member Gina Natoli. I will be the hearing officer on all agenda items today. Let me first go through some administrative items. Please turn off or silence all electronic communication devices. An agenda of today's proceedings is available on the wall near the door in the back of the hearing room. It's possible that there were materials submitted after the 11 March release of documents for today's hearing. Any additional materials are available in the back of the room on the table. There are established time limits for testimony on hearing officer agenda items. Petitioner has 10 minutes and up to 5 minutes for a rebuttal. The respondent also has 10 minutes. All others will be allowed 2 minutes each, and there is no ceding of time. Anyone wishing to testify today on any agenda item, and that includes the public comment period, must fill out a speaker card and submit it to staff in the back of the room. There is an audio and video recording being made of today's proceedings, and it will be available on the Department of Consumer and Business Affairs website within 7 working days. Is anyone aware of anyone who may need translation services today? Right, seeing none, I will go on to the general procedure for today's agenda item is as follows. First, I will ask what I will call DCBA staff to make a brief presentation. Then I will ask the petitioner to speak. The respondent will speak next, and then all other speakers will be heard. If necessary, I then will ask for the petitioner to return for rebuttals. Final decisions made by hearing officers on tenant petitions are final and are not subject to appeal at the county. So if you intend to testify today on any agenda item, and again, that includes the public comment period, I'm going to ask that you stand at this time to be sworn in. So if you are the petitioner or the petitioner's representative or the landlord or the respondent, please stand. Being sworn in does not obligate you to speak, by the way. Please raise your right hand. Take your time. If you want to come on down closer, that's fine. Wherever you're comfortable. Thank you. I need for you to stand so I can swear you in. And ma'am, if you think you will be assisting her, then I need for you to be sworn in also. All right, thank you. Could you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you may give in the matter now pending before me shall be the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. There are no corrections to the agenda, and agenda items are being taken in order. We're moving on to part 2 of the agenda, public hearing, item 2, interim rent stabilization ordinance. This is a petition for non-compliance, case number RSQ19-00493. I'll call for staff to begin their presentation.
Hello. Alrighty. This is for interim rent stabilization ordinance petition for non-compliance, RSQ 19-00493.
Excuse me. I just need for you to state your name for the record before you begin.
And I'm Shannon Lewis.
Thank you.
Alrighty, so I'll start off with the petition summary. The petitioner is Shailene Dyer. She is a tenant. The respondent is Cedric Green, who is the landlord for the property located at 1743.5 West 105th Street, Los Angeles, California, 90047. It is a petition for noncompliance and is requesting a reduction in rent in accordance with the interim rent stabilization ordinance number 2018-0045. The petition was filed back on January 14th, 2009. And the tenant visited DCBA to determine the property coverage under the ordinance. She was offered mediation on that day, but declined because she believed that her landlord would not be interested since they're currently involved in a lawsuit due to an injury that the tenant reports occurred on the property. So at that time, she was offered a petition by DCBA staff. So we went ahead and we confirmed the jurisdiction before offering the petition. As you can see here, this information is pulled from the planning parcel profile report. The property is located in the unincorporated area of West Athens in Los Angeles County. It is a residential dwelling on a property with 2 or more units, and it was built in 1948, and this information is projected up there. So some of the key issues from the petition include that the landlord provided a 60-day notice to the tenant petitioner on November 14, 2018, raising the rent from $1,500 to $1,900, and that would go into effect on February 1st, 2019. The total rent increase is in the amount of $400 or 26.67%, which is 23.67% above the allowable rent increase limit. And per the effective date of the rent increase, both the February and March 2019 rent payments will be due by the hearing date. Additionally, if a hearing decision is not issued before April 1st, 2019, another rent payment will be due. So as I previously stated, the petition was filed on January 14th, 2015. The petitioner returned the proof of service to DCBA on January 25th, 2019, declaring that a copy of the petition was sent to the respondent back on January 15th. The notice of hearing was sent to the landlord as well as the tenant on March 7th, 2019 by DCBA. So just to go over the landlord contact that we made on our end, we did contact the landlord on March 14, 2019 to determine if the notice of hearing was received, as well as to counsel the landlord on his rights under the ordinance. During that time, the landlord declared that he was not aware that an ordinance was in effect, but we did go ahead and counsel him and let him know that he had the option to go ahead and decrease the rent in accordance with the ordinance, as well as go over the just cause reasons. And the landlord stated that he'd rather appear before the hearing officer before decreasing the rent, and he also had intended to provide a 60-day notice to the tenant, which the tenant confirmed that she received. Also, in addition to that, he also stated that he did not believe that the ordinance applied to his property. We did make a second contact to the landlord on March 20th upon receiving the hearing officer's memo, and the landlord went ahead and provided us some information to the questions that were posed. But we tried a second attempt at counseling him on the ordinance, determining if he was aware of the ordinance being in place. And again, he said he wanted to be able to appear before the hearing officer along with his lawyer to speak regarding his increase that he provided. It is at this time that DCBA staff is recommending approval of the interim rent stabilization petition for noncompliance, case number RSQ 19-00493. According to the ordinance, the tenant's maximum allowable rent should be $1,545 under the ordinance. If approved, then some of the conditions would be that the landlord would need to return an overpayment that has been taken by the landlord in the amount of $355 for each month, so it totals up to $710. Per the ordinance, that would need to be returned in a lump sum or across 6 months. We also would like to state that if a decision is not issued before the 20 days is up for the hearing officer's decision, then the landlord, the tenant should only be responsible for paying the base rent as of September 11th, which would be $1,500 plus the 3%, which would bring the rent to $1,545. Thank you.
Thank you. I do have some questions for you, and they're right from my memo. Do we have a copy of the certificate of occupancy or the final building permit for the structures on the property?
At this time, we do not have a copy of either of those documents. We did go ahead and look at the planning website, viewing GISnet, as well as cross-referencing to DPW's building permit viewer, and we were not able to locate either of those.
And do we have proof of the rent that was in effect on the 11th of September 2018? The change in terms of tenancy sheet in my packet only confirms what the rent was on 1 February 2019.
DCBA does not have a copy of it, but we did reach out to both the landlord and the tenant to provide copies. The landlord stated that she would bring rent receipts showing what her rent was in effect before September 11th.
All right, thank you. And are you aware of when the tenant first occupied the rental unit on the property?
The tenant reports that she began occupying the unit on June 2015.
June 2015.
2015.
Do we know if the proposed increase was charged to rent?
Yes, both the tenant and the landlord reported that $1,900 was paid for the months of February and March.
But strictly to rent, not to some other pass-through amount?
Correct.
And do we know, has the landlord implemented any additional housing services at the property since 11 September 2018?
Both the landlord and the tenant state that there have been no new housing services.
All right. Do we know for sure how many dwelling units are on the property?
The landlord states that there is only one dwelling unit and also states that only one of those units has been occupied. But per the jurisdiction check that we did, we see that this should be a triplex, and it's actually zoned as a two-family residence.
And you see that the zoning shows that it could be a two-unit, there could be 2 units on the property, and the 3 units, you got that from the assessor's record, is that correct?
The parcel profile report.
All right, thank you. I don't have any additional questions for you at this time. I see someone else has just come in. Sir, are you the tenant? All right, thank you. Well, what I would like to do, I would like to give the landlord a couple of minutes to come in, and I believe that this is the landlord who's just come in. Are you Mr. Green, sir? Sir, are you Mr. Green? Yes. All right. What we're going to do is take a 2-minute break here to give Mr. Green a chance to fill out a speaker card, and I can get him sworn in, and then we'll begin again. So a 2-minute break. Thank you. Right, this hearing officer meeting is back in session. What I'd like to do at this time is call the petitioner, Ms. Shalene Dyer, to come up front. Ma'am, come on up front here. You'll take a seat at the table, whichever seat you prefer. That's up to you. There'll be a timer on the desk in front of you. It's set for 10 minutes. When your time starts, the green light will come on. You don't need to use all of the 10 minutes, whatever you need to do. When you have 30 seconds left, that yellow light will come on the timer. So you want to wrap up your testimony at the time, and the red light means your 10 minutes has expired. And all I ask is that you just state your name for the record before you begin. So whenever you're ready, ma'am.
Okay. Shalene Dyer.
Do you have a statement to make, ma'am?
Yes, I would like to clarify something as well. There's 3 units on the property, and just recently one of them became, tenants moved out. So it's been occupied all this, they're all been occupied all this time, and there's 3 on the property.
And did you have anything else to add to staff's presentation today? That's okay. It's just you and me having a conversation. I don't know anything. So you tell me what you think is important.
Okay. All right. Well, I'm one of the tenants. Me is one of the tenants have been there the longest so far, and I pay my rent. My dad lives with me. We pay our rent on time every month, regardless of any situations. We pay the rent on time every month. We're never late, and the only thing is I have a problem is I don't mind paying extra rent, but if things are being upgraded, but nothing has been, the building is old building, and there's nothing that's ever been upgraded aside from just a fixing of the shower knob. That's about it. Nothing else is upgraded, and I don't mind paying a little bit more, but he doesn't do any upgrade on the property.
All right, perhaps you could answer a couple of questions for me.
Sure.
Do you have a copy of your check, or can you get a copy of the check that you paid for the September rent?
Yes, I just gave it to them today when I arrived.
For the September rent?
Okay. I have my attorney's assistant. She should have a copy of that, but I gave them as well the copy of the receipts from paying for February and March, the increase. So they just have that.
That's okay. I'm really interested in the September check.
Okay, well,
September 2018.
I have my booklet, my receipt booklet with me.
All right, well, I won't be asking for that now. I just want to make sure you can get that information.
Yes,
okay, great. And you first occupied the rental unit in June of 2015?
Yes, ma'am. And
at that time, there are 3 rental units on the property. At that time, were all 3 rented?
Let me see. Yes.
And does the landlord or the property owner live in any of those rental units?
No, he doesn't, but he parks his private vehicles in the garages there because we're not allowed to use them. He takes it for his own personal use.
All right, thank you, Ms. Dyer. I do not have any other questions for you at this time. If you would please vacate the chair, I'm going to ask the respondent to come forward and make his statement.
Okay.
Thank you very much.
You're welcome.
Before you come forward, sir, I need to ask that you please stand so that I can swear you in. Would you please raise your right hand? Do you swear or affirm, under penalty of perjury, that the testimony you may give in the matter now pending before me shall be the truth, the whole truth, and nothing but the truth? Thank you very much, sir. If you'd like to come forward and take a seat. As the respondent, you have up to 10 minutes to make your statement. You don't need to use all of the 10 minutes, whatever you think is important for me to know. You heard Ms. Dyer's testimony. The only thing I ask is that you just state your name for the record before we begin.
My name is Cedric Green, Cedric Green, Green.
Thank you, sir. And do you have anything to add to the testimony?
I don't have no idea what's going on, ma'am.
Right. So on September 11th, 2018, what would the rent have been for Ms. Dyer's unit?
$1,500.
And when did you raise the rent to $1,900?
I served her notice in December.
All right. And at that time, were you aware that the interim rent stabilization ordinance had become law in Los Angeles County? All right. When you became aware of it, what did you decide to do about the rent increase?
Well, I'm here to find out what's going on. I want to do what's right.
All right. So if we were to determine that that $400, if I were to determine that that $400 increase was not allowed under this county ordinance, this county law, you would be willing to pay Ms. Dyer back the increased rent that she has paid?
Well, you're saying I'm not allowed to increase my rent?
No, we're not saying that. What the ordinance says is that you're only allowed to increase 3% once per year.
I just learned that. I didn't know anything about that.
Yeah, that's what the ordinance says.
I just found that out. Someone called me, told me about it. I didn't know anything about it.
And they called you back in January, is that correct?
I believe it was this month. No, I don't think I got a call in January.
Well, that's all right. Right, and you have nothing else to add to your statement, Mr. Green?
No, ma'am, I'm totally lost.
All right, thank you. I don't have any other questions for you at this time, Mr. Green. If you'd like to take a seat.
Okay.
I'm going to ask at the time Ms. Lewis to come back up. First, let me see if Ms. Dyer has any rebuttal. Why don't you come back on up? If you'd like to add anything. As the petitioner is allowed to have a rebuttal period. Please proceed, Ms. Dyer.
Yes, just want to clarify something. He said that he wasn't aware that he could not raise the rent. In September, when he was raising it to $1,500, I told him that I had information off the internet because I looked up in regards to the petition and stuff that I was filing, and I told him that it does state that he's only allowed to charge me 3% at that time. And he argued with me over the phone, stating that he doesn't care whatever I say or whatnot, that he was still I still have to pay that. And I had an accident on the property due to negligence because he had told my dad maybe 2 weeks prior to my accident. My accident happened on December 4th. And I was coming home and there was a hole. When I was picking up my groceries, I stepped on the top stair to open my door, and the ground opened up, and my foot fell in it and got caught, and I lost my balance, and I fell backwards down 8 steps. And I had to be picked up by the ambulance and taken to the hospital. And I tried to get in touch with him when the accident occurred. His phone kept going straight to voicemail. So and then I sent him texts. When I got to the hospital, the nurses, the staff also took pictures because I had a big lump on my head. So they actually took pictures and everything. And I tried to get it to him and call him, leave messengers or whatnot. And I did not speak to him till probably about 2 weeks later. And when he called me, I asked him, were you aware that I had an accident on your property? Because I've been trying to get a hold of you. And he said, no. I said, okay. I said, well, this is what it is. I need to see about if you have any type of renter's insurance. He told my dad, apparently, I talked to my dad that same time. He told my dad probably maybe about 2 weeks or 1 week to 2 weeks prior to my accident. My dad said that he told him that to be careful because the top level up there was kind of, I guess, not sturdy. And for us to be careful. Okay, my dad is a senior citizen, and he had a stroke before, so, so apparently he didn't transfer me, but I feel instead of him actually knowing this and did not send somebody out right away to try to fix it, I had my accident right after that. And he did raise my rent to $1,500 in September. But what happened was, when he found out, he did not give me the information that I requested, and it was 2 weeks he saw me. He came to our apartment because he was mowing the lawn at the property, and he never came to me to ask me, or even how are you doing, or nothing. He never talked to me. He had the whole fixed and everything. He'd never offered me the information that I asked him for. And then right after he found out that I had an attorney, that's when he raised my rent to $1,900. And he's never acknowledged me or anything since this accident happened. And see, he has somebody else bringing these the rent increase form letters, or he'll drop it in my mailbox. He has not confronted, said anything to me since this accident happened. So, and it makes me very uncomfortable because I didn't do anything wrong. I just wanted to make that clear. As far as he knew about the 3%, because I did tell him that I have paperwork stating that he can't do it. So he did know, but he refused to acknowledge it.
Thank you, Ms. Dyer. Thank you very much. You can take your seat. Ms. Lewis, if you'd like to come up, if you have anything to add to the testimony that's been given today.
I do not have anything to add.
All right. Let me go through a few items of discussion. I did, first of all, we also have Claudette Leslie signed up to speak. Do you wish to speak? You're not required to speak. Would you like to speak? All right, thank you. All right. Claudette Leslie. Yes, come on up, take a seat, either chair. You'll have up to 2 minutes. You don't need to take that much time. Whatever you'd like to say, just state your name for the record before you begin.
Okay. My name is Claudette Leslie, and I work with the law offices of Ira Seltzer, and we represent Charlene Dyer on her accident fall at the property. We also sent letters to Mr. Green informing him of the property and what had occurred, and we've had no response from him, no acknowledgement. We ended up having to file a lawsuit and serving him with the lawsuit. During that time, instead of an acknowledgement or a call to our office, that's when we received a copy of a notice that he served Charlene that he was raising the rent to $1,900 after he recently raised it in September. And we recently got a call back from the insurance company for the property. So he hasn't acknowledged us at all of anything that we made him aware of in writing and so forth. And I just wanted to say that in support of her statement that we've reached out to him as well.
Thank you, Ms. Leslie, very much. Now I really mean it, Ms. Lewis. Do you have anything to add?
Alrighty, yes, I did want to add one more thing. We did receive a copy of a 60-day notice of termination of tenancy that was provided to the tenant from the landlord. We have provided a copy to your county council, and we will also pass copies up to you, as well as a copy to the clerk and a copy for the landlord.
Thank you very much. Appreciate that. Ordinance 2018-0045 is very clear. My duty is to either deny, affirm, or modify a petition, whether the petition is from the landlord or from the tenant. So issues of falls on the property and issues about, in this instance, notice of termination of tenancy, that's not what I'm ruling on here today, or it's not what's before me today. What's before me is the petition for noncompliance about the rent increase. But the ordinance does require that I determine several things, and that includes whether the unit is a covered rental unit under the ordinance, when the tenant first occupied the rental unit. I need to know the rent charged to the tenant on either 11 September 2018 or the date the tenant first occupied the unit. In this instance, it would be 11 September 2018 because the tenant occupied the unit prior to that date. And a few other things, but basically all of that information is necessary for me to determine whether the increase is in compliance with the ordinance. I don't have all that information before me right now to make that decision because I not only have to make a finding, I don't only have to make a decision based on the evidence presented to me, but I have to make findings about the outcome of the situation. And to be able to make those findings, I do need some evidence. That's a little, when they talk about a preponderance of the evidence, I need to have some paperwork that shows me certain things so I can make the findings to make my decision. I will need some more information to make my decision concerning this petition. I need a copy of the certificate of occupancy or the final building permit for this property. The problem, not the problem, but a problem with the assessor's information is it's not always, what's on the website is not always correct. So what carries over to regional planning's parcel profile report doesn't always tell us the entire story. As a hearing officer for regional planning, I've had instances where a building was approved in 1948 in East LA as a commercial structure. It's just hadn't been used as commercial structure for a while, so the property owners started renting out that space. Well, that's not what the building was permitted for. So I need to know what the building was permitted for when it was permitted for residential use. And the way that you find that, if there isn't a final building permit or a certificate of occupancy on the website, is every area will have a local building and safety office. And you need to ask them for copies of everything in the parcel jacket. They will give you a copy of everything in the jacket. Our engineers, bless their hearts, they have a lot of information. Sometimes they don't have information, but it can take our wonderful engineers a while to get us that information. But I need to know if there's anything in the jacket for the property. So it's going to take a call to this office, and I don't know if that's the Southwest office. Actually, on our website, it will tell you where the regional planning office is, and the regional planning office for this area, West Athens, Westmont, is in the same building with building and safety. So that should tell you where the building and safety office is. Partly what the ordinance requires is that that has to have been issued, either the certificate of occupancy or the final building permit has to have been issued prior to 1 February 1995. So hopefully there's something in the jacket that shows a permit, or if nothing else, at least infers that a permit was issued prior to February 1st, 1995. So just get copies of everything. And you're a fellow county department, so they shouldn't charge you for that. The other thing I need, Ms. Dyer, I need a rent receipt or a statement that covers September 2018, because I have to have some piece of paper that proves to me what you were paying on September 11th, 2018, to know that this receipt that I have before me that shows on February 2019 you paid $1,900, that shows me what you're paying now, but this doesn't show me for sure what you were paying in September. So canceled check or some sort of statement that shows what you were paying in September 11th, 2018. That's the information that I need from you. There isn't any other information I need. I'm sure Ms. Dyer can get that information relatively quickly. However, I'm not so convinced you're going to be able to get the information very quickly from building and safety. It can take a while. I'm going to continue this case because I need to have that information to be able to make my final decision. Building and safety, we have a couple of dates coming up for DCBA hearings. The 28th of March is not enough time. 1 week is not going to be enough time. The 8th of April is 2.5 weeks. We already have 3 items on the agenda for that day. I'm not sure if we want to, and we'll get to the 15-day period in a second here. And then there's the 22nd of April, where there are no hearings scheduled yet. However, I'd like to confirm with County Council. The ordinance states in Section 5D that in no event shall the continuance be longer than 15 calendar days from the originally scheduled hearing date. However, it states that that's for the landlord or the tenant's petition. Do I have the authority to continue this hearing for longer than 15 days?
Yes, Madam Hearing Officer, I believe your interpretation is correct, and it is within your discretion to continue it for longer than 15 days.
Okay, very good. Then that leads to the next question, which is, past 1st of April, rent is due. So what I'm considering is tenant paying the rent that was in effect on September 11th, 2018, which supposedly is $1,500, so that the April 1 rent would be $1,500, and that if at some point in the future I find for the landlord and I deny the tenant's petition, how that difference is paid back, we would work out.
Madam Hearing Officer, I think that's also within your discretion. I would suggest perhaps adding the 3% to the 1,500 if you believe that's fair for the landlord.
Mr. Green, may I ask you to come back up? I need to ask you a question.
Yeah.
Thank you, Mr. Green. If I were to direct that, because I am asking for this continuance, that Ms. Dyer pay a rent of $1,545, which is the $1,500 plus 3%. I'm assuming you would want to have at least a 3% rent increase. Is that correct?
Yes, ma'am.
All right. Would you accept her payment of $1,545 for 1 April until we figure out what's going on?
Well,
This is a yes. This is
yes,
really simple.
yes,
Yes or no?
yes, ma'am.
Okay. Okay, very good. Thank you, Mr. Green. And I'm not going to ask you, Ms. Dyer, if you would pay that, because otherwise it would be $1,900. So I'm assuming the $1,545 on April 1st, which would be $1,500 plus the 3% that the ordinance allows. And this is until I can make a determination on the petition and rule on the petition. All right, thank you both. You can certainly return your receipt, Mr. Green. Thank you. So now, Ms. Lewis, I'm thinking either the 8th or the 22nd. What seems preferable for DCBA?
The better date is April 22nd.
Right. I think that's probably wise, just because, again, bless their hearts, we love our engineers, but it may actually take, I'm sorry to say, someone driving over to the office and standing there while copies are made. That's been my kind of my experience in the past. Did you have something to add, Ms. Lewis?
Yes, the tenant has provided the September 2018 rent receipt, and we've made copies of it.
Fine. Hold on to that. Since I've asked for 2 items, please just hold on to that until you receive the information on the certificate of occupancy or final building permit. And with your next memo for the April 22nd hearing, just include that information in the packet for April 22nd.
Okay.
All right, thank you. And I just want to double check with County Council first. Mr. Trinh, do you have anything to add?
No further comments, thank you.
All right, thank you very much. Then, since it will take some time for this information to be obtained, I want to provide sufficient time for the information to be gathered and reviewed. In this instance, item 2, case number RSQ19-00493 is continued to 22 April 2019. That will be in this hearing room. Oh, hold on, Mr. Green. At 10 a.m. Yes, Mr. Green, you had a question? If you could come up to the microphone, it's just that since this is being recorded, that way we're sure to hear you.
Okay. I'm extremely busy. I got sick members in my family, and I am prepared to things I'm not in. If it's ruled that I'm not in compliance with the city ordinance, to just give the money back. And I would like the 3% increase. I spoke with my attorney about it, and he's acknowledged me about it. He says, that the ruling is in effect, so.
All right, so Mr. Green, let me just summarize what I think I hear you saying. You may not be able to be here on the 22nd of April, but if I were to rule in favor of the tenant, you would be all right with a rent increase of up to that 3% to $45, and then paying back the overage paid in the meantime.
Correct. As a matter of fact, Your Honor, I brought a check to just resolve this right now because I really have other things to do.
Well, since I'm a bureaucrat, right, and we have paperwork in front of us, and while it'd be nice to say, well, sure, let's just close this down now, the petition's been filed. Unless the petition is withdrawn, and frankly, if I were the tenant, I'd want to wait for the paperwork to be finished to make sure that I had a ruling in my hand that says I can do this. If I'm going to get the information that I've asked DCBA staff to obtain, we'll have a nice package that can be closed up, and we have all of our information in one place. And maybe I'm being too bureaucratic, but I'd really prefer to just have all our T's crossed and our I's dotted. I very much appreciate you saying this, Mr. Green. And so the continuance will really be a formality. It'll just be for administrative reasons.
I know.
To put the information in place. Yeah. But since
just that I'm pretty busy.
I understand, and now I understand when we come back on April 22nd that we may not see you here. And if something changes in the meantime, please let DCBA staff know so we know whether or not to expect you. But thank you very much for saying that. I appreciate it. All right, with that then, item 2 is continued to 22 April 2019. Thank you very much, folks, and item 2 is concluded. April 22nd, Mr. Green? It's April 22nd. I could ask staff to send you a notice. Staff's more than happy to send you a letter just reminding you that the hearing is being continued, and to the tenant as well, even though they're here. 10 a.m., 10 a.m. April 22nd, it's scheduled for 10 a.m. 10 a.m., sir. Thank you, Mr. Green. Thank you, Ms. Dyer, very much. I appreciate it. The last item on the agenda is public comment. I don't have any speaker cards for public comment, therefore I'm assuming we have no one here for that. With that then, the hearing officer is adjourned to 10 a.m. Thursday, March 28th, 2019. Thank you.